so I'll just tell you exactly what I think. I think that the county has an agenda, they follow this agenda, they overregulate, and then part of this is you have the opportunity here to be the first to say, we're gonna do this completely non-regulatory. We're gonna have the 5-year plan be the regulator. We're not gonna spend any more wasted money on this at the county level. And you have the opportunity to do that. And so I think what I would like to see to do is take the part of your slide off that says regulation and work on the non-regulation. And allow the people that's voice to be heard. Instead of a few people that feel like we have to be the most regulatory environmental group in the state of Oregon. And that's where I think we're headed.
Well, we definitely are taking this additional time over the next year to develop that non-regulatory side of it, evaluate it, and see how far we can go with it in terms of, can we do the entire program that we need to with that? Do we need some part of it to be regulatory? Where does the balance fall? So, Jean, you had a question a while ago, or a point.
Well,
I want
yes.
to make sure that you get a chance.
What I am concerned as I look at what you're proposing with the overlays, that we're going to have too much regulation in some areas. If you do get if you adopt the regulatory program, and so that was my question. I'd like to know a lot more about what you are thinking when you talk about overlays, because then I think it's Joanne's question too. Where I think it's going to put a big burden on a lot of agriculture. That's one thing that I'm real concerned about.
Mm-hmm. Okay.
If there's an overlay on an ag zone, how's the real estate lady going to know whether what I do is regulated or not?
I asked Greg.
And I may disagree with Greg.
Right. Well, right. Our goal is, if we adopt a regulatory program, to have it very, very clearly spelled out where it applies, or what it applies to, and what it does not. And
So would you go by property lines?
We go by the use, the activity that's occurring. So if you are farming, that's not our jurisdiction. If the thing that you're doing along the stream is farming, then we're not involved. But if you own farmland, but you're putting in a BMX track down next to the river, well, that's not farming, so that falls under our regulation. So it's clearly defining what applies and what does not. That's going to be critical, and we're.
If you can include up to 20 acres of woodlot, I don't know how much property you have to have the 20 acres on, because that's not defined. So that as long as I break it here and farm a little bit, I guess I can go 20 more acres down.
Nick, can we make sure we get? I think I saw some other hands, folks that didn't have.
Yeah,
a chance
we'll come back. We'll come back to you. Mimi?
I kind of want to take a step backwards. I'd like to know about this committee. When I first came here, the RWAG, which I guess is a group, was mostly agency people, and most of those people aren't here anymore. And on the website, it doesn't say who belongs to the RWAG. And I see that in the last meeting I was a participant, and I thought I was only an observer. And so I just like to say explanation about how this committee is and how it's going to work and what kind of influence they will have on this project.
It's a fair question, and the role and the composition of the RWAG have evolved over the 2+ years we've been at this. And that's fine from our perspective. It's not an official advisory board to the county commissioners. It was a advisory group developed by staff to get public and agency and other interested people's input as we go along. And I don't know that we have figured out exactly the role of the RWAG over the next year plus. We probably need to add that into the draft timeline and project
So
report.
does that mean that you may have another group of just agency people that would be
We-
your advisory?
We don't have a
Right.
plan for that. We haven't done that. I don't expect to do that. I think there's value in having everybody together in a group so that you get cross fertilization of ideas and discussion and so on.
Yeah, maybe when I first was starting to pull folks together, and we laid out the idea of having the scientists in the same room as the landowners and the agency people. It was based on a lot of work that Extension Service did when Tillamook County was going through their riparian ordinance development. They didn't have a combined, mixing of the different interests. It was, here's the science team, here's the landowners, and you can imagine that there was a lot of negative and a lot of frustration between. So tried to make it so that everyone can attend any time. I think though, as you were seeing more agency folks at the beginning, because I personally asked them to come and present the programs that they administer, like the Ag Water Quality Program, Department of Forestry, Forest Practices Act, having the Stewardship Forester come by, having DEQ present. So that was to give that background information in those materials at the beginning.
Where did the Soil and Water Conservation Group, where do they fit into this for the county?
They've been participating the whole time, giving us information.
Are you doing the same thing?
No.
How can you not do the same thing if they're doing water and soil?
Well, there's plenty of water and soil around.
Huh?
There's plenty of water and soil. No, there's definitely different roles and missions from the county versus what the SWCD does. And if you want to get into some of the specifics, Donna can tell you what those are. The county, we're local government. SWCD is working just on voluntary projects with landowners that are interested in doing it. But we're definitely trying to make sure that we're providing landowners with information and resources to get folks connected with the Soil and Water Conservation District and the programs they have to offer.
Nick?
I'm listening to this as well, my own input. I see where part of your problem is going to be, and that's you're trying to micromanage versus macromanage. When you start micromanaging people's lives, and you can't put your picnic table there, but you can put it there.
With a
You can't, with a permit and all these fees. You can't have this much stream, but you can have this much stream. You can't have this, but you can have that. You're gonna do the same thing that they're doing in the justice courts, where you're taking away the judge's ability to apply an appropriate sentence to a convicted person who did something wrong. This is your first one, we're gonna take it easy on you and behave as long as you behave. No, you gotta do 10 years now because you stopped micromanaging or macromanaging and went to micromanaging.
Yeah, that's a good point.
And you start micromanaging my life and a lot of the people in here, you're gonna have a problem.
No, that's a good point. I mean, we run into those similar complaints when we tell people how close they can build to a stream now, or that they have to get flood insurance and those sort of things that we hope are, getting that protection of public good and health and safety of folks and the environment, which is what we're trying to do on this project. So I definitely hear what you're saying, and I think that's valid. And we don't want to be in the position, believe it or not, to layer on stuff that is to the point of, as you put it, micromanaging, that we can't actually implement something. We've had throughout the project, we've had a lot of lessons learned from past riparian programs that have gone in place locally or regionally or throughout the state, picking up on what has worked better and what hasn't worked better. That's why we're incorporating all of the flexible stuff, as you mentioned, so we don't get caught in this micromanaging situation.
Micromanaging can be done in many different ways, though. It doesn't have to necessarily be law, it can also be, as, like she just said, fees.
Right, and that was a big
And that's another way to
concern.
do it, which is the same thing as saying, oh, you can do it, but you're gonna have to pay this exorbitant fee. The amount of fees to build an addition on your house now are totally ridiculous. It costs you more for the fees and permits than it does to actually build them, you know, and studies and all this stuff, just to build a little thing. And this is, you know, so you're, either way, you're micromanaging.
So yeah, not only the rule, but deal with the fee issue, which can be a limiting factor for a lot of folks.
Well, I hear your point. That part of what we've been trying to do as we go through this is to develop ways to not micromanage, but to more broadly allow landowners flexibility in a way that we don't have to be involved in reviewing or permitting. And so that's one of our goals. The trick for us is finding the sweet spot where we can, you know, allow enough, as much flexibility as we can, but still be within statewide planning goals, goal 5 and goal 6, and our DEQ requirements. And because those are all pushing towards more of the cut and dried, here are the rules, obey them. So I hear your point. I want to